Thank you very much, and thank you very much for braving the weather to come to a planning talk. That must be a first. So a little bit of background on me. I was called to the bar in 2004, admitted as a solicitor in 2006. I also have a background as a chartered surveyor. I was in valuation for a while, in agency for a while, about 20 years experience in planning consultancy. And we work mostly with developers, investors, landowners. We have worked with councils in the past as well, but most of the thrust of our consultancy is to add value to development schemes, some of which we participate in, some of which we advise on as consultants. And so what I'm trying to deliver here tonight to you is a few gems, partly inspired by some of our own experience in the market as well. What we're seeing is it's becoming much more difficult, it's a much more competitive market out there to get that winning bid. But also, as a result of the risk being taken by some investors who are then failing to raise the requisite finance, they're losing their relationships with their investors, which I wouldn't want you to do. Those sites are sometimes coming back onto the market. So you've got to work harder for the planning gain and on the due diligence as well. So let's look at a few ideas. So the planning department is the department that you're going to have to front up to more and more as the market develops. And unfortunately, planning officers haven't got a terribly good reputation. They're often seen as cretins amongst developers. And some of them, they are a bit of a mixed bag. You don't necessarily need a great deal in terms of qualifications to become a planning officer. I once saw a planning officer being cross-examined in public inquiry, and he more or less admitted that because he wasn't a member of the Royal Town Planning Institute, he wasn't bound by a code of conduct for the Royal Town Planning Institute. I saw my barrister's head buried in his hands at that point, and he immediately turned to his opposite number and said, "I hope you won't be seeking costs against us for that." In any event, it can be a bit of a dangerous game. If you go in cold with planning officers, you need to do a bit of due diligence before you go in, but it's also important to build those relationships. The area that I'm about to break into in terms of permitted development, prior approval, and then leading on to planning, and the way it blends in with planning is potentially, it's quite a complicated area. So I'm going to try and slim it down and perhaps streamlining it a little bit. There are two golden threads that I want you to bear in mind as we go through these slides. One's called the fallback position, and the other one is called future proofing. I'll develop those ideas as we go through. But effectively, fallback position is where you're in a position where you can say to the local authority that normally we would not be able to do this under policy, say, for instance, a change of use from offices to residential, because they would have strong policies to protect against the loss of employment in those areas. However, if you can obtain a prior approval certificate or a certificate of lawfulness, you're able to say to the council, however, we have a fallback position. We could do this in any event if you were to try and stand in our way on the planning, and therefore, can we come to kind of some sort of sensible compromise? You're using it as a negotiation point. It's the worst case scenario for them. And in terms of future proofing, where you're bidding, for instance, in our experience, in office to resi schemes, then you need to also bear in mind how some of those factors, such as parking and highways, are going to be taken into account further down the line when you're seeking to add that extra story or go for that extra space as well, which will also carry with it a little bit of supplemental parking demand as well. So you're effectively trying to build in a margin in terms of the constraints that you're working with. So you've got to go in very carefully with officers. There are some consultants out there who can be a little bit bullish. We don't like to be bullish with councils. I think we try to be the smiling assassin to a degree, particularly ask a lot of questions, go on your fact-finding, and try and build that relationship as well. So our starting point here in this journey is with permitted development, and it starts with lawful use. And here's a quick summary in terms of the lawful use constraints. Bear in mind some of these time frames. We looked, for instance, and I'll give you another example in a moment, but we looked, for instance, at a building which a client had bought. It was a relatively small house in northwest London, in the London Borough of Barnet, and it had 6 self-contained flats in them. They were all below nationally described standards, so if they were one-beds, they were all below 50 square metres, for instance. They didn't have planning. If you went back in for a retrospective application for planning permission, it would have been refused. The first question we asked the client was, how long have they been in this use? And they've been in use for at least 4 years. So what we do is we put in an application for a certificate of lawfulness. We put it in with evidence such as statutory declarations, evidence of council tax, electoral reform, the plans, anything that we can put together that paints a consistent picture of more or less 4 years continuous occupation. And then within the framework of a certificate of lawfulness, that goes in with a small fee to the council, and usually as it's a lawful application, a lawful development application, it has to be considered usually under delegated powers, so you avoid having to engage with members and the political aspect of committee as well, and they normally get decided within 8 weeks as well, so it's effectively like getting your planning permission within 8 weeks. There's no conditions attached, they can't apply conditions to it. And so that immediately had a bumper impact on the value of that property. This is a rather larger example that we dealt with. This is in Hampstead. Our client had bought some years before an old Jesuit mission hostel. It was a Class C2 use. It's the London Borough of Camden. And if you were to apply to London Borough of Camden to move out of Class C2 use, Camden would have said no, certainly without proof that there wasn't a demand for it. He'd moved into what was effectively, it's a 22,000 square foot property and pretty much exploded out of into all 4 corners of the property with the staff, with various family members, guests moving in, so on and so forth. And they were using some rooms for storage, so on, et cetera, et cetera. Now, he bought it for about 16 million, 17 million at the time. We got a certificate of lawfulness after 4 years with, I think we put in together about 10 affidavits that went in with the application and a barrister's opinion because we thought that this was likely to be very contentious to the council, particularly because of the size and also because of the implications. You'll see at the bottom there that if you get a certificate of lawfulness, you don't have to pay community infrastructure levy, you avoid affordable housing charges, and effectively he gets planning permission to go from 0 to 22,000 square foot of residential use within 8 weeks, and he's just saved himself about £5 million of affordable housing payments, £1 million of SIL, and added at least roughly £10 million onto its current use as well. So that's quite powerful stuff. Now, our firm mostly looks, because of the nature of the clients that we have, they mostly look at office to residential, but we do look at other permitted development and prior approval regimes as well. Unfortunately, I don't have a room for a 3-hour talk on permitted development, so we're just going to concentrate mostly on the office to residential and a little bit on light industrial as well in a moment. So effectively where we're looking to add value, first of all, is we're questioning the nature of the location. We have to consider all these factors that come into play. We are wearing part of a development hat when we are doing this. Although we are a planning consultancy firm, we are also effectively adding a planning plus service to our clients because these factors make a massive difference as to how you're going to play the future-proofing, the traffic and highways impacts of your strategy. Now, the first thing you'll have to ask is whether or not prior approval is available. Again, we're asking ourselves, is there a fallback position? And we can argue. Look at whether or not there are any restrictive covenants. Do you have to take out insurance? Is there likely to be some possibility of enforceability of a restrictive covenant if you're operating in breach of those covenants by transferring to another use? Article 4 directions are coming into play more and more with some local authorities. They don't like permitted development. It's rather ironic that in a situation where we need to build and we need to provide more houses, what their aversion to it is they just feel as if those units are too small, whereas actually there is a very high demand for them. In some cases, these micro units that we're building out of 30 to 35 square metres, because they're much more affordable or at least reachable for those people who want to get their foot on the housing ladder, they're paying £50,000 to £100,000 less in some cases than they would have to pay for a competing one-bed unit in that area. Then it really opens up the market for these people. And sometimes housing officers and planning officers just don't get it. And it's really disappointing to see these Article 4 directions come into force. But you need to look diligently at the council's websites to check if they're there. Sometimes there are Section 106 agreements which are in place which prevent you from going over to an alternative use. Planning conditions as well. We are looking at a scheme at the moment for roughly 35,000 square foot with development partners. The current landowner is quite a well-known housing builder, and they went in for prior approval. They were turned down because there is an existing condition which restricts it to B1A office use. And so the council had to refuse planning permission on that, or rather prior approval. However, I looked at this, called up the officers, and I had a chat with them about whether or not one would be able to discharge that planning condition, because we found an example of another property in the same local authority area which managed to remove that planning condition. Some conditions, you need to have a look very carefully at what the purposes of that condition was being imposed. We think we'll be able to remove it, and therefore it'll open up the prior approval play for us. SANG, Sites of Alternative Natural Green Space, is a very complex area. Happy to take questions on that later. It's mostly in the southeast and areas which are close to natural upland and heathland. They also have particular restrictions on prior approval, and they're related to the Habitats Directive, which is currently read into law on prior approval. There are the usual conditions on General Permitted Development Order as well. There is a possible new housing need test which has come in on Article 4, which constrains the way that local authorities have to think about whether or not they're going to bring in Article 4 directions. So in office to residential permitted development, there are a number of things that you need to check or need to look at in order to maximise the opportunity, whether or not there are plant rooms, undercrofts, basements, etc. You also need to look at the possibility of sufficient parking and access. In London, there is a heat map, I'll show you in a moment what it looks like, which is called the Public Transport Accessibility Level, which you can look at on a website called WebCat, W-E-B-C-A-T, WebCat PTAL. It'll take you to a website, you put in the postcode, and basically it'll come up with a number for that postcode. 0 is almost very little or no public transport accessibility, 6 is the highest, and the higher you move up, then the greater the density you can propose and the smaller the units. We're often using barristers' opinions more and more to try and steer through some of these schemes. There have been a couple of issues that have come up with regards to whether or not we'd be rightly applying for accommodation in a roof space, where you can't actually see that as a full floor at the moment. We are allowed by law to do that, and therefore we've won a few bids on that. We are developing out at the moment a scheme which was bought for £4.25 million with investors' money in Stanmore Library for 39 units. 11 of those units are in the roof space, and had we not identified those units, we wouldn't have won the bid. So that's what the heat map effectively looks like. You put your postcode in on the top left, and it will give you a PTAL value. Light industrial use PD has come in recently. We'll have to wait and see how relevant this is. A lot of retailers are finding it difficult to live on the high street, and they're moving out to retail parks and light industrial units. So some of these spaces are actually being taken by them and not for residential. They are also, the PD right doesn't include the right to do external works, and there's often an awful lot of work that needs to be done to these buildings in order to bring them up to standard, whereas the office buildings, some of them don't actually need any external work, or some of them might need a little bit of extra cladding as well. So that's one particular reason why some of these are very slow, some of these examples are slow in trickling through and coming through. Article 4 directions are also coming into place with some of the boroughs in London, where they're very concerned about the loss of employment use from these areas as well. Other factors to look at include flood risk and contamination. One reason you might go for light industrial, even though it's limited to 500 square metres of floor space, is to establish that fallback for a bigger scheme. You can say to the council that, well, we've got PD on this building, we could convert at least part of this to residential use tomorrow, so can we talk sensibly about a planning permission scheme on the rest of it? It's a quick case study that we worked on with a client. This was a building in the London Borough of Ilford. It was occupied by Redbridge. The council turned it down on parking and highways grounds. They actually did not offer any compelling evidence in the inquiry, and we had two schemes running. One was for 92 units, the other one was for 104 units. We won both on appeal and got full costs against the council for not offering any evidence on parking and highways. We've got a lot of the accommodation in the Undercroft as well, because of course that's ancillary to the B1 use. You recall I mentioned about sites of alternative natural green space. This is an example. This was in Rushmore Borough Council. We're working with a client on this at the moment, going through pre-planning. It's actually for 114 units at the moment. It says circa 120. SANG basically works like community infrastructure levy. There's a fixed tariff contribution that has to be made to basically keep people off the heathland and the upland. And then, of course, we'll be subject to affordable housing as well. So this is a scheme that, because of the Habitats Directive, because of the relationship to SANG, the council say we will not allow PD on this scheme, and therefore you have to go through a full application for planning permission. If you know how to do so, if you know what the opportunities are and how to play it, then obviously you can manage that risk, and it opens up other opportunities such as this to you. This is a scheme that we got through we actually sourced this for a client. I remember sitting down with him in sort of September a couple of years ago, and he'd already had these agency particulars through from Jones Lang LaSalle. The building's on the left. It's a bit of an ugly duckling. It's in Hyams Park, and we got permitted development through for 42 units. The scheme that we're trying to promote is the one on the right, which would include the 42 units in the existing building on the left, but another 2 to 3 stories, going up to about 70 to 80 units. We'd had a lovely meeting with the council in pre-app, because we've got a massive car park at the back which backs onto an overground station, and the council has said, that's a great looking scheme, we really like it, but we're not going to grant planning for it because there's not enough development on the site. And it's probably the first time I've heard this in about 20 years. My client was shocked. He needed a good stiff drink after that, but we're working on a much bigger scheme as well at the moment. This has come up because we have we had a strong relationship with the chairman of the local neighbourhood group beforehand, which I fostered from a previous bid around the corner. They hadn't yet produced their neighbourhood plan documents, but he had told me over lunch that that building was going to feature in it, and they were promoting up to another 2 stories in it, so they would probably support an application. So we had a bit of an inside track before we put in the bid on that. You're going to come up across all sorts of interests, and there's an awful lot of bureaucracy and diplomacy that you'll need to handle within the planning process. This is a summary of the planning process you'll have to work through. I won't go through it stage by stage, we don't have enough time, but it can be quite a long, drawn-out process. Try and look at CGIs, create a vision, and give some imagination, give some vision to the scheme. If you get that bang on quite early in the process, then you can really carry officers along with you. There's a scheme I'm probably going to have to skip over. I'm just running out of time. But this was in the Greenbelt. It had listed buildings, a Grade 2 listed coach house and stables. That one on the left. 2 locally listed buildings and TPOs all over the site. It's being built out and it looks exactly like that at the moment. And we increase it to 9 units in total. Albeit the fact it's in the Greenbelt, we also managed to get about 15% increase in floor space and volume because we positioned this as a heritage restoration project. I was involved many years ago on the Chelsea Barracks litigation against Qatari DR, and I was acting for the Candy Brothers Family Trust at the time, and Prince Charles was one of the third parties that stuck his oar into the Chelsea Barracks scheme, you recall. Third-party interests can come from all sides, and sometimes you've got to be prepared to compromise. Affordable housing, very quickly. I'm around later in the break if you want to ask me questions on this, but there is a cascade approach generally to affordable housing. They'll look for it on site first, then they'll say, well, does your client have other interests off-site where we can put the affordable housing, and if not, then they'll look at money and financial payments. But they'll try and come back to the scheme afterwards when you're building out and you've sold, say, maybe about 80% of the units to see if they can get top-up contributions. The London Mayor is looking at that at the moment and trying to encourage a fast-track approach in the draft revised London Plan, which is out for consultation until March. Community infrastructure levy, basically with PD schemes, it's a complete set-off with the existing floor space, so you shouldn't have to pay community infrastructure levy as long as the units were at least used for at least 6 continuous months in the last 3 years. If not, you may have to pay SIL. But whatever happens, don't panic, and hopefully that won't be you stuck this evening on a train. But any questions, I'd be happy to answer.
Okay, what we're going to do, we're going to take 2 or 3 questions. I'm going to bring David back at the end after Palmdeep's talk, and we'll do a little bit more Q&A. So we'll have a little bit now and a little bit later on as well. Sorry, Yusuf.
Barry, thank you for that.
Let's just get a mic to you, if that's okay. Can I get someone to help it? Oh, you're going to do that. All right, Barry, just... Thank you very much. Yeah, go on.
Hello, James.
You can stand up, yeah.
Thank you for that. It's very interesting. I'm looking to site myself at the moment, which is light industrial commercial use in a residential area. The council are very keen to put it to residential. What would you suggest I should really look for? Obviously, CIL payments, all this sort of thing. They want it. How strong can I negotiate?
How large is the how large are the buildings on the site?
The building is about 10,000 square feet. There's about 3/4 of an acre of land.
Right. Is it all one building?
2 buildings at the moment.
And are either of the buildings below 5,000 square foot?
Yes.
Okay, so you could apply for you could apply for PD in the first place to at least pocket the fallback position, just in case they get really difficult in negotiations, because you can use that as a threat against them and say, well, listen, if you're going to really hold things up, we may as well go ahead and crack on with a PD and we just apply for any external revisions. Because also that secures your position with regards to the change of use, which is often the most difficult area to negotiate with officers, because they may say, we'd like to see something happening on that site and we'll support you, but you'll still have to jump through the hoops in complying with policy. They need to leave an audit trail to say, well, has there been any marketing, so on and so forth. So that's one of the things that you'll have to look at. Try and establish PD on it if you can. Also, as a backstop, speak to local agents, have a very robust marketing report ready to really pummel the hell out of the light industrial market there as well. But you also need to look at floor size and space standards, amenity area, possible Section 106 of payments, and affordable housing. Although, again, that's where the light industrial permitted development right can come in handy if it's available to you.
Right.
Because that relates to the change of use. It doesn't relate to physical alterations, but it's the change of use on which the affordable housing request attaches itself.
Yes,
So you may be able to play very tough with them in terms of affordable
Right.
housing and say, listen, we don't have to offer this to you, but we'll offer it to you so you give us something back.
Right. When you say the buildings, there's one building small, one building is big, or split into units. Would it be the units or the physical building that you're talking, the 5,000 square feet?
You can apply for a PD on part of a building because the definition of a building in relation to at least this part of the Act includes part of a building as well.
Thank you. Very helpful. Thank you very much.
I think you've highlighted that a lot of this is a game of chess, isn't it?
It is.
It's a very
positioning
strategic
yourself.
game.
Yeah.
Okay, who else has got a question? We'll take. Let's take this lady. Let's take Angela at the front.
Hello. Thank you, David. That's an excellent conversation there and very intriguing. I'm interested in the SANG, the sites and the natural green, and
Yeah.
when you're saying about the density. Could you explain that a bit more,
The
please?
density.
Yeah, i.e., between 1 and 6, and your planning, the way
Oh,
you
right,
look at
yes.
planning.
Well, saying, is it PTAL, really, that you're probably getting that mixed up with? Because it's the grading from 1 to 6 or 0 to 6 relates to the public transport accessibility level. So when you're looking at parking in highways and you're trying to figure out whether or not you need to provide parking on site, ideally you want to be in an area which is 4 or above. However, with the Ilford example I gave you, there are 100 units. There are only about 50 car parking spaces, and so 50%, roughly 50% of those units didn't have any car parking spaces. Now, you might expect to see in a public transport accessibility level of 4. That was in a PTAL area of 2. So don't lose heart if it's in a relatively low PTAL area. It just means you really need to top it up with a parking and highways report. And more likely you're going to need a parking and highways report if any of you are looking at sites outside of London where they don't have PTAL. They probably have some supplementary planning document which tells you what the transport and parking policies and what their local access requirements are like there. So that gives you some idea. So we topped it up with a parking and highways report because in London, the PTAL algorithm is skewed depending upon how close you are to an underground station. So there was buses running up and down that road all the time. It was really close to shops. So it gave the wrong impression of how actually accessible it was. It was only about 10 to 15 minutes walk from Ilford town centre. So that's hopefully that helps you.